Parliament yesterday passed the Uganda People's Defence Forces Amendment Bill 2025 after a heated debate that exposed deep divisions over the military's jurisdiction to try civilians and the role of the General Court-Martial.
It's very possible, by the way, that the Prime Minister does not even know the contents of the committee report, but she was very quick to rise up to defend.
Honorable
Speaker, I am on procedure. Legal Committee Chairman, Honorable Namuyangu, I am on point of procedure. You're always absent here. You don't even know the rules.
Please.
Prime
Minister, order.
The bill, which was tabled by Defence Minister Jacob Oboth, constituted a major overhaul of the UPDF Act, introducing 84 clauses ranging from structure reforms within the Defence Forces to the contentious provision on general court-martial jurisdiction over civilians. Today, we have met the Foundation for Human Rights Initiative Executive Director Livingstone Sewanyana to discuss these provisions. He highlighted the variations between systems and procedures in dispensing civilian and military justice.
As a matter of general principle, military courts are meant for military personnel. Civilian courts are meant for civilian personnel. The systems and procedures vary. When we talk about military justice and civilian justice, the procedures vary. However, what is in common are the standards of fairness, independence, and of course, a proper outcome.
Sewanyana expressed dissatisfaction with the manner in which the bill was passed, stating that many stakeholders were not consulted.
Ordinarily, when a bill comes before Parliament and is subjected to a committee scrutiny, they normally write to organizations like us. They write to individuals and experts to provide an input into that bill. In this particular case, nothing of that sort was done. We were never consulted. We were not able, to have an input. So the speed at which the bill has been passed raises considerable concern.
In agreement with Sewanyana, Job Kija, a human rights defender, says these provisions serve to give the government excessive power against Ugandans and particularly against politicians.
We are seeing a regime that has been around for 40 years, whose sole objective right now is really to entrench itself further. And of course, as any regime stays longer and seeks to entrench itself further, it comes up with more draconian laws, draconian actions, and more high-handedness with which it handles citizens.
He adds that the past provisions are no different from other laws that have been enacted with the aim of suppressing human rights in various ways.
It is just part of the larger scheme of putting in place laws and policies that are geared towards curtailment of civic freedoms. A lot of power is also being given to the military. On the one hand, you have, in terms of the executive, you have executive power being vested in the Chief of Defence Forces. You have legislative power being vested in the High Command. And then you have judicial power as per the law that was passed yesterday being vested in the court-martial. So you actually have a total return to a military state.
The bill, which also seeks to clarify key components of military justice, aligning them with constitutional provisions, is now awaiting the President's assent, a crucial step in its journey. Betty Mudondo, NTV Tonight.